Welcome to Concerned Citizens Presents. Concerned Citizens of Laguna Woods is an organization dedicated to peace, economic and social justice, good government, and a clean environment. Every month, we invite an expert to enlighten us on a topic related to our mission. Because Village TV videotapes these presentations, we can share that expertise with a larger audience. We hope you enjoy today's broadcast.
Good afternoon, everybody, and welcome, Dean Chemerinsky. This is your 12th talk to concerned citizens of Laguna Woods, starting in 2008 with our first annual Supreme Court term review. We greatly appreciate your generosity in spending time with us. Erwin Chemerinsky needs little introduction for those who've been to his talks and read some of his many articles and books. His founding of UCI Law School also contributed greatly to our community and to all of Orange County. We've now gotten over his deserting OC to lead UC Berkeley Law as dean. Thanks a lot, but we can get along without you, or maybe not. Just two more things, please. First, a fairly recent study that counted citations of legal scholarship found Erwin was cited most often and by a significant margin. And second, his latest book that'll be out in a few weeks, August 20th, is provocatively titled, No Democracy Lasts Forever, How the Constitution Threatens the United States. That'll take some explaining, and we're all ears. So, Erwin, the floor is yours.
Thank you so much for the kind introduction. Thank you for welcoming me to speak again. I wish I could be there with you in person, but I'm glad at least there's the opportunity to talk with you by Zoom. I was told to talk 35 to 40 minutes and then leave the last 20, 25 minutes for your questions. And I was asked to talk about both the Supreme Court and the new book that Jonathan just mentioned. Let me try to tie them together. In terms of the Supreme Court, it was another momentous year in the United States Supreme Court. The Supreme Court decided 59 cases with signed opinions after briefing and oral argument. It's about the same as a year ago or 2 years ago, a bit more than 3 or 4 years ago, but it's much less than the Supreme Court used to be deciding. As recently as the 1980s, the court was deciding over 160 cases a year. When William Rehnquist finished as Chief Justice in October term 2004, the court decided 85 cases. To go from that to under 60 is a very substantial reduction. In terms of the Supreme Court's docket, if I was to come up with a theme for this year, something that captures the Supreme Court term that ended on July 1st, I would say that it's a court divided. The division is reflected in many things. Of the 59 cases, 23 were 6-3 decisions. Another 5 were 5-4 decisions. So almost half were split 5-4, 6-3. Of the 6-3 decisions, the most frequent split among the justices was the 6 in majority, were Roberts, Thomas, Alito, Gorsuch, and Kavanaugh. And the 3 in dissent were Sotomayor, Kagan, and Jackson. And this was present in some of the most important cases of the year. But there were also 6-3 decisions where the 3 in dissent were Thomas, Alito, and Gorsuch. They have emerged as the most conservative bloc on a conservative court. But just relating this doesn't give the sense of how divided the court was this year. Even when there were unanimous cases, the justices very much disagreed with one another. There's a case this term, United States versus Rahimi. It involved the Second Amendment. It concerned a federal law that makes it a federal crime for a person or restraining order domestic violence case from having a gun. The Supreme Court 8-1 upheld the law, but there were 7 different opinions written from among the 9 justices sharply disagreeing as to the rationale. There was another case that was about an issue regarding abortion, Moyle versus United States. It involved a federal law, the Emergency Medical Treatment and Labor Act, and it said that if a pregnant woman went to an emergency room of a hospital and she needed medical treatment, the hospital would have to stabilize her condition. Biden administration rules said this includes providing an abortion, where she requested one and protecting her health required it. Idaho law says abortions are allowed only to protect the life of the woman. Federal court said there's a conflict. Federal law says that you've got to provide abortion if the health of the woman requires it, but Idaho allows it only if the life of the woman requires it. The federal law preempts the state law. The Supreme Court granted review in the case. It held a briefing. The oral argument was on April 24th. And then the Supreme Court decided the case. Didn't decide the case, they dismissed the case. They did what's called dismissing as certiorari improvidently granted. No decision, they sent it back to the Ninth Circuit. But even though there was no decision, there were 4 different opinions written. Justice Kagan, joined by Sotomayor and Jackson, said that they thought that the Idaho law was preempted, but the court didn't need to decide it. Jackson dissenting, saying, I think the Idaho law is preempted, we should decide it. Alito saying, joined by Thomas and Gorsuch, the Idaho law is not preempted, and Idaho should be able to protect potential life. And then Barrett, Roberts, and Kavanaugh say, we shouldn't decide at all, we should just send it back to the Court of Appeals. The court doesn't decide, but there's still 4 different opinions. All of this is my indication of a court that's deeply divided. In terms of the individual justices, I've talked in past years with you of, is this really the John Roberts court? This term it was. Roberts was the justice most often in the majority this year. He was the majority in 96% of the cases. He dissented only once all year. He wrote so many of the most important cases of the year. I think it was a term where we really heard the voice of Justice Amy Coney Barrett. To be sure, in virtually all of the ideologically divided 6-3 cases, Barrett was with the conservatives, but sometimes she wrote separate opinions to take a more moderate approach, even though she went along with the conservative result of the majority. She also wrote some of the most important cases of the term. Quite predictably, Justice Thomas wrote a number of opinions, dissenting by himself or writing by himself, saying we should overrule longstanding precedent. Justices Sotomayor, Kagan, and Jackson each had occasions for writing vehement dissents, and Justice Alito wrote a lot of angry opinions. Justice Alito wrote only 4 majority opinions all year. That's the fewest of any justice. It's the fewest in a year of any justice in recent memory. And his angry tone was notable. You might have seen an article, an op-ed in the New York Times by Linda Greenhouse. And it was about the abortion case I mentioned just a moment ago, Moyle versus United States. And Linda Greenhouse referred to it, I'll quote her word, as unhinged. And it was just referring to the vehemence of Justice Alito's anger. But I would say that anger was present in so many of the opinions this year. In the late 1940s, someone wrote a book about the Supreme Court and referred to them as being like scorpions in a bottle. This was referring to a Supreme Court that had justices who famously disliked each other. It was especially about Black and Jackson, who by all accounts loathed one another, about Douglas and Frankfurter, who loathed one another. Well, if I had to describe the current Supreme Court to you, I would say it's angry scorpions in a bottle. What I want to focus on is the Supreme Court relative to democracy, because that lets me tie together what I regard as the most important cases of the year with the new book that Jonathan mentioned that I have coming out. So let me start with about 2 cases from the Supreme Court. Both involve Donald Trump, and I want to suggest to you reasons to be concerned about each with regard to our democracy. The first of these is Trump versus Anderson. It involves Section 3 of the 14th Amendment. Section 3 says that if a person has taken an oath to uphold the Constitution, and the individual then participates in a rebellion or insurrection, that person is not eligible to be a senator or representative, to be an elector for president or vice president, or to hold any civil or military office. Section 3 of the 14th Amendment was adopted to keep those who had participated on the South side of the Civil War, the rebellion side, from holding political office in the future. A large number of people were immediately disqualified from holding office in the United States government until Congress in 1872 removed the disability. Section 3 of the 14th Amendment in the last sentence says that Congress can remove the disability from holding office by 2/3 vote of both houses of Congress. As you know, in December of 2023, the Colorado Supreme Court, in a 4-3 decision, ruled that Donald Trump was disqualified from serving as or being a candidate for president of the United States, being on the Republican ballot for the Colorado primary, by virtue of his having played a role in the insurrection of January 6th. The Colorado Supreme Court said, being a president under the Constitution is a civil office. Donald Trump had taken an oath to uphold the Constitution. And Donald Trump's behavior with regard to January 6th was participating in an insurrection. The United States Supreme Court reversed the Colorado Supreme Court. The oral arguments were held on Thursday morning, February 8th. I listened to them. After the arguments, I was convinced that the United States Supreme Court was going to reverse Trump. It did so, and perhaps because everyone expected that result, there hasn't been much careful analysis of what the Supreme Court said. Even though it was unanimous, there were 3 different opinions, and even though it was unanimous, I'm skeptical of the court's reasoning. There was what's called a per curiam opinion. That means an opinion of the court. Instead of having one justice write the opinion, we'd say, this person wrote it and others join. It's a per curiam opinion of the justices in the majority. And the per curiam opinion gave 2 reasons why the Colorado Supreme Court's ruling should be reversed. First, the Supreme Court said, it's not for state courts and states to enforce Section 3 of the 14th Amendment. The Supreme Court said, if we let states enforce Section 3 of the 14th Amendment, there'll be a patchwork across the United States. Somebody might be disqualified in one state, but allowed to run in another state, and that wouldn't work when you talk about election for president. And then second, the Supreme Court said, Congress needs to adopt a law so as to implement Section 3 of the 14th Amendment. In more technical language, the Supreme Court said, it's not self-executing. There has to be a federal statute that would provide a basis for enforcing it. Justices Sotomayor, Kagan, and Jackson wrote an opinion which is called concurring in the judgment. That means they agreed with the result of the majority, but not the reasoning. If you read, though, their opinion, it sounds so much more like an angry dissent than a majority opinion or a concurring opinion. They said that there was no reason for the Supreme Court to go beyond the first justification. If states can't enforce Section 3 of the 14th Amendment, the analysis should stop there. No reason to go on and consider whether it takes federal legislation. There was a leak that was reported in the press that their opinion was originally written as a dissent, but then they made it concurring in the judgment. Justice Barrett wrote a concurring opinion, and it was interesting. She agreed with Sotomayor, Kagan, and Jackson that the first justification given was sufficient, but then she chastised Sotomayor, Kagan, and Jackson for writing separately and for the tone of the opinion said, especially on such controversial issues, we should tone down the rhetoric. And it's interesting that she chose to attack some of her fellow justices. And you can tell from the tone of their opinion, they didn't take it well. Let me suggest to you that even though it was unanimous, the Supreme Court's reasoning is very problematic. Take the two reasons the court gave. First, it said it's not for state courts and states to enforce Section 3 of the 14th Amendment. Why not? State courts and states enforce the 14th Amendment literally every day. Take police searches and arrests. If the police officer from Laguna, California, or Irvine, or Oakland, California, is alleged to violate somebody's rights with a search or an arrest, and the person who was searched or arrested challenges it in state court, the state judge is enforcing the 14th Amendment. The way the Fourth Amendment is applied to the states is through the 14th Amendment. If it's alleged in state court that a local government, any local government, violates the First Amendment with regard to freedom of speech, the way it's enforced is the state court is enforcing the 14th Amendment. State courts enforce the 14th Amendment, as I say, literally every day. Why not this provision of the 14th Amendment? Well, the justification the court gave us, it would be undesirable to have each state determine for itself whether somebody could be president. But it wouldn't be for each state to decide for itself. Ultimately, it would be for the Supreme Court to decide. Colorado's courts ruled. It went to the United States Supreme Court. And then the United States Supreme Court determines, was Section 3 of the 14th Amendment met? That's a constitutional question, like other constitutional questions that the court resolves. The court would then be deciding it for the whole country. The court would be deciding once and for all, was the Colorado Supreme Court right that Donald Trump was disqualified by Section 13, Section 3 of the 14th Amendment? If the court said yes, then Donald Trump would be disqualified in every state. If the court said no, Donald Trump would be allowed to run in every state. Every case begins in a state court or in a federal court within a state, but ultimately it's the Supreme Court that would get to make the determination. It would be one determination for the entire country. You wouldn't need to worry about a patchwork of decisions. The second reason the court gave was it should take Congress to pass a law to implement Section 3 of the 14th Amendment. Why? There are other provisions of the Constitution that limits who can run for president. To run for president, somebody has to be 35 years old. To run for president, somebody has to be a natural-born citizen. To run for president, it has to be that somebody hasn't already served 2 terms as president. Those are enforced, I would assume, by courts, even without a federal statute. Why not this? In 1883, the Supreme Court, in what's called the Civil Rights Cases, specifically ruled it does not take a federal statute in order to enforce the 14th Amendment. In the technical language I used earlier, the 14th Amendment is self-executing. Why then do you need a statute? There's another problem with this too. As I mentioned to you, the last sentence of Section 3 of the 14th Amendment says Congress, by 2/3 vote of both houses of Congress, can remove the disability of somebody from running for office. Doesn't that tell us what the 14th Amendment intended with regard to Congress's role? That it doesn't take a statute to implement the 14th Amendment, but if Congress wants to remove the disability, it can do so. Here's the bottom line for this case in the future. The Supreme Court has essentially read Section 3 of the 14th Amendment out of the Constitution. No state can enforce it, can't have any enforcement without a federal statute that doesn't exist. So it doesn't matter what somebody does in violating Section 3 of the 14th Amendment. It never can be enforced. Long ago, in Marbury versus Madison in 1803, the Supreme Court was clear that the Constitution is meant to limit what can be done, especially by government. And those limits are meaningless if they can't be enforced. The Supreme Court rendered Section 3 of the 14th Amendment meaningless. And in doing so, of course, said that Donald Trump could still run for president and be president again. The other case the Supreme Court decided with regard to Donald Trump, I think history will regard as one of the worst Supreme Court decisions ever. It's not hyperbole. I think there is a wall of shame of Supreme Court decisions that history regards as terribly misguided. Dred Scott versus Sanford, where the Supreme Court invalidated the Missouri Compromise and held that enslaved people are property and not citizens, even if born in the United States. Plessy versus Ferguson, that upheld separate but equal. Korematsu versus United States, that said that the federal government could evacuate Japanese Americans from their home and place them in what President Franklin Roosevelt called concentration camps. I fear that Trump versus the United States will be part of that wall of shame. Let me try to explain why. And I think this should be nonpartisan, though the decision was anything but. I'm not an originalist, but I think the framers of the Constitution were deeply distrustful of executive power. In the Articles of Confederation that preceded the Constitution, it was a very weak president who served one-year terms. In the Constitution, there was still this great apprehension of executive power. The framers of the Constitution wanted to resist royal prerogatives. I think if there's anything that the Constitution wanted to reject, it was the powers of someone like a king. Trump versus the United States is actually about a power that kings had. Kings could not be sued or prosecuted. There was a maxim in English law, the king can do no wrong. Think of that as I talk about Trump versus the United States. Jack Smith, the special counsel, indicted Donald Trump in Washington, D.C. There were 4 counts to the indictment. One was about his attempt to use the Justice Department to illegally stay in office in 2021. One was his trying to persuade Vice President Mike Pence to throw the election to him in Congress on January 6th. A third was Donald Trump trying to pressure state officials to give him additional votes in 2020, such as what he did with regard to the Georgia Secretary of State. And the fourth was Donald Trump's role with regard to the insurrection on January 6th. Donald Trump moved to dismiss the indictment on the basis of absolute presidential immunity, saying he was in the White House while these things went on, and somebody who was serving as president could never be criminally prosecuted for actions taken while in office. The federal district court in Washington, D.C. ruled against Donald Trump. The special counsel, Jack Smith, asked the Supreme Court to take the case at that time, and the Supreme Court could have if it wanted to. It didn't. It had the case go first to the United States Court of Appeals to the District of Columbia Circuit. The case was brief, it was argued, and then the D.C. Circuit handed down a decision that was unanimous. It included both liberal and conservative judges, saying a president does not have absolute immunity from criminal liability. If a president violates the law, the president is amenable to prosecution. The Supreme Court granted review. It scheduled an additional day for oral argument in the term on Thursday, April 25th. One might have thought that the Supreme Court would expedite the handling of the case. That's what it did in United States versus Nixon in 1974. But it not only didn't expedite, didn't hand down a decision until July 1st. And as the press reported, the Supreme Court's decision was everything that Donald Trump could have hoped for and more. Chief Justice Roberts wrote the opinion for the court. Justice Thomas and Barrett wrote concurring opinions. Justice Sotomayor wrote a blistering dissent, as did Justice Jackson. Chief Justice Roberts began his opinion by talking about how the Constitution meant to have a vigorous and strong executive. The court said, if president faces potential criminal liability for what was done in office, that will chill being a vigorous, active president. And the Supreme Court then, founded on that premise, said there's 3 zones of presidential power. One is where the president is carrying out the official powers under the Constitution or a statute. Powers the president has being commander-in-chief, pardoning people, overseeing the executive branch like the Justice Department. Anything the president does in carrying out those powers can never be a basis for criminal liability. It is absolute immunity. The second zone, the court says, is the outer perimeters of presidential power. And the court said there's presumptive absolute immunity that can be overcome. And then there's the areas where the president isn't carrying out duties or even at the outer reach of the presidency. He's acting as a private individual. The court said there's no immunity. But the opinion even went further than this in providing great protection for the president. The court said the president's motives don't matter. So imagine that the president tells the Justice Department to prosecute somebody just for the purposes of political retribution. Overseeing the Justice Department is part of the official duties. Absolute immunity. Therefore, it doesn't matter the president's motives. Or to take an example that came up in oral argument that's been much discussed. Imagine the president orders Navy SEALs to go and assassinate a political rival. Being commander-in-chief is a core power of the president. Absolute immunity. Therefore, the president can't be criminally prosecuted. Or imagine the president takes bribes to issue pardons. Issuing pardons is part of the absolute immunity of the president. There can be no criminal liability. And the court said you can't use as evidence anything done in carrying out the official duties of president to overcome the president's absolute immunity. The court then went on and considered aspects of the indictments. One aspect of the indictment, as I said, was Trump talking to the Justice Department to ask them to come to his aid to keep him as president. The Supreme Court said the president talking to the Justice Department is absolute immunity. President Trump trying to convince Vice President Pence to throw the election to him in Congress. The court said, well, that's at the outer perimeters, presumptive absolute immunity. What about the other things that Trump did that seem clearly not protected by any immunity? Asking state election officials to find votes for him. Encouraging the insurrection on January 6th. Did the court say as to those no immunity? No, all the court said is those will send it back to the lower court. Justice Thomas wrote a concurring opinion in which he said, I think the special counsel is unconstitutional. And on Tuesday of this week, Judge Eileen Cannon in Florida declared the special counsel unconstitutional. There's much to say about what's wrong concerning this, but the purpose of her as a federal trial court judge, the Supreme Court resolved the issue. In 1974, in United States versus Nixon, the Supreme Court was explicit that the Attorney General can appoint a special counsel. Judge Cannon just said, well, that's not controlling, that's dicta. It was controlling a Supreme Court opinion. There are two decisions of the Federal Court of Appeals in the District of Columbia coming to exactly the opposite conclusion of Judge Cannon. Many other judges have done so. Justice Thomas, as a Supreme Court justice, can say the Supreme Court should change the law, but it wasn't for Judge Cannon, a federal trial court judge, to do this. Justice Barrett wrote a concurring opinion saying she thought that the court could provide immunity, but write a narrower opinion. Justice Sotomayor wrote what will probably regard it as one of the most iconic dissents. It was angry. She gave all the examples that I mentioned and said, for each of them, immune, immune, immune. She talked about how the Constitution was all about rejecting royal prerogatives. And she said, now what the Supreme Court has done is make the president a king above the law. Usually a Supreme Court justice, even in a strong dissent, concludes by saying, I respectfully dissent. That's not what Justice Sotomayor said. Instead, her end was, with fear for our democracy, I dissent. Why the fear for the democracy? The core of the rule of law which is a cornerstone of our democracy, is that no one, not even a president or a former president, is above the law. What the Supreme Court did in Trump versus the United States 2 weeks ago is effectively make the president above the law. Those who occupy the White House in the future know now that so long as they're carrying out an official power, they face no criminal liability. Donald Trump has already said if he's reelected, he will use the Justice Department for retribution against Joe Biden and other Democrats. If he does so, carrying out his threat, he faces no consequences for doing so because of the court's decision in Trump versus the United States. The reason I think Trump is such a dangerous decision is because it is a threat to democracy and the rule of law. Well, let me use the last 10 minutes before questions to transition it to the book that I have coming out this summer. As Jonathan said, it's titled No Democracy Lasts Forever: How the Constitution Threatens the United States. It's based on a premise that I hope is wrong, but the premise is that our democracy is in grave danger. The reality is that democracies are there until they're not. We're all familiar with countries that once were democracies, but are no longer. There is a rise of authoritarianism in countries around the world. Countries that were once liberal democracies often are not. Think of the move towards authoritarianism in India, or in Turkey, or in Hungary. I was disconcerted this week. I was in an article yesterday in the Washington Post that said that J.D. Vance says is one of his political heroes is Viktor Orban, the autocrat who rules Hungary. In fact, the Republican National Committee held meetings in Hungary and has invited Orban to come speak to them. If that's the model for our government, it truly is a threat to our democracy. There are many measures of the threat to democracy. Our government has the lowest public approval ratings in history. We have a president whose approval ratings are again in the low 30s. The Supreme Court's approval ratings are the lowest as long as they've been taking the polls. Congress's approval rating is 18, and that might be 18 people, not 18%. Our country is more politically divided than it's been at any time since Reconstruction. One measure of division, when Donald Trump was president, his approval rating among those who identified as Republican voters was 87%. His approval among those who identified as Democratic voters was 11%. Never before has there been that kind of a gap. And of course, with regard to Joe Biden, the gap is somewhat less, but not much less. It's the second largest gap of that sort in history. Take any major issue and think of the enormous divide in our country between red states and blue states. One has to wonder, is what unites us as a country still greater than what divides us? January 6th, from this account, is a symptom of a democracy in great danger. After all, prior to that day, never had there been an insurrection. Well, in the book, I try to answer the question, why? And what I want to suggest to you is the choices that were made in drafting the Constitution that were necessary at the time have come to haunt us since. There were Faustian bargains that were essential to get approval at the Constitutional Convention of the States, but there were mistakes then. Because of changes in population and partisanship, they've become much more salient in recent years, and they've all been made much worse by Supreme Court decisions. Let me give you examples. The Electoral College. I think the Electoral College was a mistake when it was adopted in 1787. In a democracy, the candidate who gets the most popular votes should be the chief executive of the country. That seems to me fundamental to the definition of democracy. But the framers adopted the Electoral College in part based on distrust of the people. Alexander Hamilton in the Federalist Papers explained it should be an elite that chooses the president, a distrust of the masses. The Electoral College was also adopted to help states where there was slavery. The states with enslaved populations were worried that they would be at a political disadvantage because their enslaved populations couldn't vote. Well, a compromise was reached where enslaved individuals counted as 3/5 of a person in allocating seats in the House of Representatives. The Electoral College gives to every state electors that are the sum of its representatives and senators. The Electoral College, thus, very much was to help slave states. This is not just hindsight. At the Constitutional Convention in 1787, Hugh Williamson, a delegate from North Carolina, defended the Electoral College as helping Southern states by counting their slave populations. James Madison, a delegate from Virginia, said the same thing. In the 20th century, the Electoral College never mattered. Now, once was a candidate who lost the popular vote, the victor in the Electoral College. But in this century, twice already, in 2000 and 2016, the loser in the popular vote won in the Electoral College. George W. Bush in 2000, Donald Trump in 2016. And it almost happened 2 other times. In 2004, if Al Gore had carried the state of Ohio, he would have become president, though losing the popular vote. And in 2020, if 42,800 votes had changed in 3 states, and 42,000 people is less than fits into Dodger Stadium, then Trump would have become president, though losing by 7 million votes. What I suggest in the book is the way in which there's been population shifts in the country and the way in which there's been partisan shifts since the 1960s mean that the Electoral College is going to continue to create a real possibility that the candidate who loses the popular vote could end up winning in the Electoral College. At this point, according to polls, Donald Trump has a good chance of being chosen as president in November. But no one believes that Donald Trump can win the popular vote in November. It again will be the Electoral College. A second choice that was made in drafting the Constitution that I think was a mistake was giving 2 senators to each state. At the time the Electoral College, the Constitution was drafted in 1787, the difference between the most populous state, Virginia, and the least populous state, Delaware, was about 9-1. Now, if you compare the population of California and Wyoming, the difference is 68-1. And yet California and Wyoming both get 2 senators. And of course, that also contributes to the problems of the Electoral College. I'll give you a statistic that to me was startling. In the last session of Congress, there were 50 Democratic senators and 50 Republican senators. The 50 Democratic senators represented 40 million more people than the 50 Republican senators. Compounding this is the filibuster. Like me, you probably have an image of the filibuster of Jimmy Stewart from Mr. Smith Goes to Washington, holding the lectern until he collapsed of exhaustion. In the 1970s, the rules of the filibuster were changed. Now, somebody doesn't have to actually stand up and hold the lectern to filibuster. Now it's a virtual filibuster. So long as a senator indicates a desire to filibuster, it takes 60 votes to overcome it, unless it's budget legislation. This makes it so difficult for the Senate, for Congress, to do anything, and that contributes to loss of faith in government and the crisis in democracy. Another flaw with regard to the Constitution was giving the Supreme Court justices life tenure. The framers never intended the justices would serve as they do now, literally for decades. Average life expectancy in 1787 was 37 years. Interestingly, from 1787 until 1970, the average tenure of a Supreme Court justice was constant, 15 years. Since 1970, the average tenure of a Supreme Court justice who has since left the bench is 27 years. Clarence Thomas was 43 when he was confirmed in 1991. If he remains on the court until he's 90, the age Justice Stevens left the bench, he'll be a justice for 47 years. The Elena Kagan was 50 when she was confirmed. If she stays to 90, she'll be there 40 years. That's too much power in one person's hands for too long a period of time. Amy Coney Barrett was 48 when she replaced Justice Ruth Bader Ginsburg, who left the bench at age 87. If Barrett stays till she's 87, she'll be a justice until the year 2058. I think that the Supreme Court, through its decisions, has very much made the crisis of democracy worse. I think here of cases like Citizens United versus Federal Election Commission, which said that businesses can contribute unlimited amounts of money against the elector defeated. I think of Shelby County versus Holder, which gutted key provisions of the Voting Rights Act. Another flaw in the Constitution was how difficult it is to amend. Under the Articles of Confederation, it took unanimous consent of all the states to change the Constitution. So the framers thought that they were making it easier. It takes 2/3 of both houses of Congress and 3/4 of the states under the procedure that's always been used. But to get 2/3 of both houses of Congress and 3/4 of the states to agree is at this point virtually impossible. Since 1791, the Constitution was amended only 17 times, and 2 of those were to create and repeal prohibition. The Constitution is far too difficult to change. And of course, if we're going to talk about flaws in the Constitution, we have to talk about race. Alexis de Tocqueville in the early 19th century said that race was the fundamental flaw upon which American government was founded. And we've seen that throughout American history. And we continue to see in our society today the legacy of the tragic choices that the framers of the Constitution made with regard to slavery and with regard to race. So the point of my book is to say that all of these flaws in the Constitution have a large amount to do with the crisis democracy facing the country. And then we've got to think about what are the alternatives? What can be done without constitutional amendment? What can be done and how realistic is it by constitutional amendment? Is it time to think about a new constitution for the country? And if we do none of this, how likely is it that we'll remain the United States? I will make for you a dangerous prediction now. If Donald Trump wins the presidency, and if Republicans win both houses of Congress, I think we will see the first serious secession movement since the Civil War. I don't think it will succeed in the short term, but I certainly think we'll see a lot of discussion about it. So that's why I titled the book, "The Crisis, No Democracy Lasts Forever, How the Constitution Threatens the United States." And you can certainly see how the Supreme Court's decisions in the Trump cases fit with that. I promised I'd save the 20 minutes for questions, and you can ask me about any of the other cases of the Supreme Court, or about the ones I talked about, or about my book, about my grandchildren, anything you want to talk about.
I will start with a question where you left off on your book, exactly where you left off. I also would like to let you know, as we know, that that regarding the Electoral College, 4 weeks ago today, the third Thursday of June, our entire program was on the Electoral College versus the National Popular Vote Interstate Compact. So we've been paying attention to that. Question. Your publisher's summary of No Democracy Lasts Forever says you write that to avoid, quote, political Armageddon, close quote, you suggest a new constitutional convention. It's called an Article 5 convention, because we must, quote, rewrite the entire Constitution from start to finish. Wouldn't that risk a runaway convention and losing many current individual rights to powerful, big money special business interests, extreme right-wing ideologues, authoritarians, and maybe Christian nationalists, etc.?
I think it makes no sense for a country to be governed by a document written in 1787 for a very small agrarian slave society. There is going to be a point at which people realize we need a new constitution. The more the Supreme Court is committed to originalism and limiting the Constitution's meaning to 1787, the less sense it makes to be governed by that document today. So I propose that there should be a national constitutional convention. I propose that whatever it promulgates should go before the people in a national plebiscite vote. It shouldn't go to the states for approval. I'm not following the procedures of Article 5 of the Constitution and what I advocate for. Yes, you're right that there could be a runaway convention. It could propose terrible things. But remember, then it would still have to be approved. It wouldn't go into effect automatically. And my hope is that it was terrible in the way you described, it would get rejected. My hope is that when there's another constitutional convention, and there will be someday, that the men and women who are there will live up to their responsibilities and take their roles seriously. I don't think that James Madison and Alexander Hamilton and Benjamin Franklin and George Washington were divinely inspired in 1787. I think they took their role very seriously. And I believe that those who were at the Constitutional Convention would take their role seriously, try to keep what's good in the document, and propose something better than what's there now. And then it would be up to the people to decide whether to adopt it. And so my answer to your concern about risk is, yeah, there's a risk, but I think the ratification process, it would ultimately be the check.
Thank you. On Supreme Court reform, President Biden reportedly will or did come out for 18-year term limits and effective ethics rules that might include a recusal process. But Biden still avoids reform to rebalance, or as I like to call it, thinking of George Lakoff, framing unpack SCOTUS to undo McConnell's theft of seats for Gorsuch and Barrett by adding 4 seats. You've said expansion should be considered. What's your current view on those reforms? And what do you make of HR 3422 that would just add, that's all it would do, just add 4 seats, pending now with 65 co-sponsors in the House, including Jerry Nadler and Jamie Raskin. Although it hasn't moved this year, has no chance to pass yet until control of the House flips and public opinion for reform is built.
Let me take the reforms you mentioned in the order in which you described them. The first possible reform is for Congress to pass an ethics statute that's stronger than the rules the Supreme Court adopted in November, and that has a method for determining recusal of justices. I believe it is constitutional for Congress to do that. Congress can't control the decisions in a particular case in the Supreme Court, but it certainly can regulate the institution. Congress sets the number of justices, the salary for justices, and the like. The Supreme Court took the ethics code that applies to all of the judges and changed the word shall, which is mandatory, to should. And the court leaves recusal to each individual justice. I think Congress should fix that by statute. Term limits. I have long argued for 18-year non-renewable terms for Supreme Court justices, but I believe it would take a constitutional amendment to do that. And I don't think that there is the political will to have passed 2/3 of both houses of Congress and 3/4 of the states. Rebalancing the Supreme Court. At this moment, with a Republican House, there is no chance whatsoever. Even if there's a Democratic House and a Democratic Senate and a Democratic president, it can only happen if the Democratic Senate were willing to eliminate the filibuster for it, because you know the Republican senators would filibuster, giving a Democratic president additional seats on the Supreme Court. So my response to rebalancing the court is, when we've got a Democratic president, a Democratic Senate, a Democratic House, it's worth talking about it. But at this moment, it's just symbolic, because there's not any chance in the world that could happen with a Republican House.
Following up on just one part of your answer, you said it would take constitutional amendment for the 18-year term limit. And I assume you're thinking of the during good behavior life tenure provision, but federal law has provisions for senior status that would include salary and all the other business, and senior judges could be assigned to cases. So wouldn't that take care of it?
No, senior status applies to federal court of appeals and federal district court judges that are created by federal statute. The Constitution doesn't create those positions. The Supreme Court is created by the Constitution. And the Supreme Court has always said, including very recently, the Constitution is interpreted through history and tradition. History and tradition has always been when somebody is nominated for the Supreme Court and confirmed, that is their seat for life until they resign or they die. This would change that understanding. And my sense is that as much as I want term limits, if it's going to be, you have to change Article 3 of the Constitution, because otherwise the Supreme Court justice has that position for life.
Okay. Is the Supreme Court's most recent seizure of political power from Congress and regulatory agencies, in various cases last June, what Steve Bannon calls smashing the administrative, quote, deep state, is that even greater than what the Supreme Court did in Marbury versus Madison in 1803?
No, it's not greater than Marbury versus Madison, but yes, it is deeply troubling. Marbury versus Madison created a framework for government that's lasted ever since 1803. And I could go through all the things that it did that continue. These two decisions from the end of June, from June 27th and June 28th, I think are terrible rulings, but they don't rise to the level of significance of Marbury versus Madison. Let me quickly tell you about them. One is Loper Bright Enterprises versus Raimondo. In 1984, in Chevron USA versus Natural Resource Defense Council, the Supreme Court said that when a federal agency interprets a statute, courts should defer to it, the agency, if the statute's ambiguous and the agency is reasonable. Let me give you an example. The Clean Air Act says that the Environmental Protection Agency can set air quality standards. If the EPA says, here's how much of a particular pollutant can be emitted, the courts are supposed to defer to the agency's expertise. In Loper Bright Enterprises, the Supreme Court overruled Chevron and said, it's for the courts to determine the meaning of statutes, no deference to the agencies. So it's an enormous shift of power from agencies to courts. And here's why it matters. Business has long wanted Chevron to be overruled. Business and those regulated want to make it easier to have the regulations overturned in courts. Overturning Chevron deference does that. The other case decided the day before Securities and Exchange Commission versus Jarchezi, it involved the Securities and Exchange Commission bringing a fraud action against George Jarchezi and his business within the agency. The Securities and Exchange Commission found that Jarchezi had committed fraud, imposed a penalty of $300,000. The Supreme Court, and again, it was a 6-3 decision, said that agencies can't impose penalties, that in order for an agency to seek penalties, it has to go to federal court. Well, the problem with this is there's dozens of agencies involving 200 different federal laws where the agency gets to impose the penalty and reviewed by the court. Now, all of those go to court. This is part of a Roberts Court that's very much intent on lessening the powers of administrative agencies. Why does it matter to all of us? I think it's going to be much harder for agencies to regulate the environment, to protect our health and safety, to stop unscrupulous business practices because of the Roberts Court's decisions. These are very pro-business decisions by a pro-business court.
You just described two of the very biggest decisions. But here's this question. The Supreme Court handed down so many huge cases in June that many got little or no media coverage, even though they'll cripple agencies' ability to regulate for public health, safety, and welfare. One of those little-known cases, it said, is Corner Post versus the Federal Reserve. Seems like just a very technical little case involving statute of limitations. But please tell us what it held and whether it may, in fact, really devastate regulatory agencies.
Sure. Imagine that an agency adopts a rule. How long is there to challenge it? In the year 2000, the Food and Drug Administration approved mifepristone, part of a 2-drug protocol for inducing abortions medically. How long is there to challenge it? Well, federal law says you have 6 years to challenge an agency action. And it was always thought it was 6 years after the agency acts that you have to challenge it. Corner Post versus Governors of the Federal Reserve was another 6-3 decision. Justice Barrett wrote, and they said, you have 6 years from the time that you are injured, not 6 years from the time the agency acts. So imagine that the FDA approves mifepristone in 2000. It's not, you have till 2006 to challenge it. If somebody could claim to be injured by the FDA decision today, they have 6 years from today to challenge it. Justice Jackson wrote the dissent, joined by Sotomayor and Kagan, and Justice Jackson said, this is going to have a staggering effect. That was her word, staggering, because it makes it so much easier to challenge agency actions forever. And again, what you're doing is shifting power from the agency and increasing power in the courts to oversee what the agencies have done. I think if you put it together with Loper, Bright, and Sharkezi, you see a court that is very hostile to the administrative state.
But the silver lining is that that's a statute, and it's up to Congress has the authority, right, to amend it and define the running of the statute of limitations.
Yes, Congress could amend the Administrative Procedures Act to say it's 6 years from the agency action. Congress, I think, could reinstate Chevron deference if it wanted to. Congress can't change the Supreme Court's decision about the right to go to federal court rather than an agency, because that was based on the Seventh Amendment right to jury trial in civil cases.
Here's another question about Congress's power. And by the way, it'd be interesting to see what the politics of amending the APA, the Administrative Procedure Act, to clarify the statute of limitations is. Be interesting to see how the politics work out. But here's a question that also relates to Congress. Congress gets the last say when SCOTUS badly interprets a statute by amending it or enacting new law. If the court's bad decision is based on the Constitution, SCOTUS' word is still final. But what about all the recent crazy new so-called doctrines? Think of the the major questions rule, and rules not based on the Constitution nor statute, just made up out of thin air. Does any legal, constitutional, or political reason stop Congress from weighing in, at least opine by resolution, if not pass actual law, to correct bad court decisions under its constitutional authority to regulate lower courts and Supreme Court jurisdiction? And even if not valid in the court, wouldn't Congress' opinion carry weight, including political and/or public opinion?
If the Supreme Court is interpreting the Constitution, Congress cannot override it. But I want to be subtle here and say, if Congress has found that the Constitution, if the Supreme Court has found that the Constitution is the limit on government, that the government can't do something that's unconstitutional, Congress can't change that. If the Supreme Court says, interpreting the Constitution, that there is no constitutional limit, like the court saying there's no constitutional right to abortion, then Congress can act. Congress could pass a law creating a national right to abortion, or Congress could pass a law outlawing abortions. Unless it is a decision based on the Constitution, Congress can override anything the Supreme Court does. Congress, to override it, has to do it by statute, passing both houses of Congress, giving to the president to sign or veto. A resolution is nothing but a sense of Congress. It has no legal effect and probably wouldn't be paid much attention to. But in answer to the first part of the question, if it is constitutional, Congress can't override it. If it is non-constitutional, Congress can. In terms of the clause in Article 3 of the Constitution, Section 2, that says, the Supreme Court's appellate jurisdiction is subject to the exception and regulations as Congress shall make, what that means has never been decided by the Supreme Court. It's unclear what Congress can do under its power to create exceptions and regulations. For a long time, it was conservatives that wanted to use this to try to take away the ability of the Supreme Court to hear abortion cases or school prayer or busing cases. Now, liberals are trying to think about how might they use the exception and regulations clause.
Well, thank you very much. And folks, put your hands together and thank Erwin Chemerinsky for a wonderful talk. Thank you very much.
Thank you. My pleasure. Thank you for having me.